Hello and welcome to the YouTube channel of Lucknow University Legal Aid Center. Myself Aishwarya Bhatt, and today we will talk about Protection of Women from Domestic Violence Act 2005. Now, talking about this act, it is a very comprehensive, well-written, wide-ranging and holistic act consisting of 37 sections divided into 5 chapters. The objective of this act is to ensure the protection of the victims of domestic violence. Now, without further ado, let's begin talking about various provisions under this act. Section 3 of this act explains what a domestic violence actually is. Domestic violence covers sexual, mental, verbal, economic, physical, all kind of abuses, and also the threats to inflict the same. For the purpose of better understanding, it categorizes abuses into 4 categories. The first one is physical abuse. Now, physical abuse refers to any kind of bodily harm that is inflicted on the victim of domestic violence. It also includes harassment or harm to the body, life, health, security, safety to the women, along with assault, criminal intimidation, and criminal force also comes within the ambit of physical violence. The second category we have is that of sexual abuse. Now, sexual abuse includes abuses which are sexual in nature, which degrades, disparages, or otherwise violates the dignity of the women. The third category we have is that of mental or verbal abuse. Now, mental, emotional, or verbal abuse is something that has not been recognized in India over a long period of time as a form of violence because it was seen as trivial. But for the purpose of this act, any kind of insult, ridicule, repetitive taunt relating to dowry or incapability to give birth to male child, etc., has been recognized as a form of domestic violence. The fourth category we have is that of economic abuse, which includes restrictions on the use and enjoyment of the resources, the financial resources to which the victim was entitled to, along with the disposal of the resources to which she was entitled or was having an interest in without her assent. Now, this is something that explains domestic violence in a wider perspective. However, this is not exhaustive. For the purpose of this act, aggrieved person can be any woman, like any woman who has been living with the respondent in a domestic relationship and who alleges that the respondent has inflicted domestic violence on her. Now, this has been explained under section 2 of the act. The term respondent has also been explained in section 2Q of this act, which says that respondent can be any adult male who has inflicted domestic violence onto the female. It also includes male and female relative of the husband or male and female relative of the male partner in case the relation is that of marriage or the one that resembles marriage. Yes, for the purpose of this act, live-in relationship has also been recognized. Talking about section 4 of this act, it says that any person on behalf of the victim can file the complaint known as domestic incident report in the office of the protection officer or the police officer. Clause 2 of the same act talks about the fact that no criminal or civil liability would be imposed on the informant. Section 5 of the same act talks about the fact that it would be the responsibility of the protection officer or the police officer to inform the victim of domestic violence that there are several orders, there are several protections which are available under this provision, along with section 498A of the IPC that talks about the punishment on the perpetrators of domestic violence, along with the free legal aid services which has been provided according to Legal Services Authorities Act 1987. According to section 6 of the act, it is the duty of the shelter homes to provide the shelter to the victim in case she needs. Section 7 of the same act talks about the duty of the medical facilities. Section 11 of the act talks about the fact that it would be the responsibility of the government to spread awareness about the provisions of this act through sensitization and periodic awareness programs. It also ensures that cooperation among the various organs is very much necessary in order to ensure proper execution of the provisions of this act. Section 12, clause 4 and 5 talks about the fact that it would be the responsibility of the magistrate to ensure that the trial, the first trial or the first hearing takes place within 3 days of the receiving of the application. Clause 5 of the section 12 talks about the fact that it would be the responsibility of the magistrate, or the magistrate should endeavor to dispose of the cases relating to domestic violence within 60 days of the first hearing. Talking about the penalty provisions, if the respondent or the protection officer does not comply with the orders of the magistrate, for that purpose we have section 31 and 33 of the act, which says that there are provisions of the imprisonment of 1 year or 20,000 rupees of fine, or both, if the respondent or the protection officer does not comply with the orders of the magistrate. Subclause 3 of section 31 talks about the fact that the protection officer or the police officer or the magistrate must take into consideration while dealing with the domestic violence issue that 498A also arises, and may file a complaint under that also. Now these are certain provisions which are there. Talking about the relief that are there, that are available to the victim of domestic violence, we have section 18, 19, 20 and 21. Section 18 talks about the fact that magistrate may issue an order against the respondent to restrict his entry into the area, into the space where the victim resides or where she frequently visits. Also, a restriction can be imposed on the respondent to not communicate or not establish any kind of communication with the victim if she does not wishes to have the same. Section 19 of the Act talks about residence order, that the magistrate may order the respondent to not enter the space in which the victim of domestic violence resides. Also, the respondent cannot evict the victim of domestic violence from the place where she ordinarily resides. Section 20 of the same Act talks about the fact that monetary relief may be provided in order to recompense in case where the victim of domestic violence has suffered monetary loss, either due to loss of job or rental payments or medical facilities, etc. Section 21 of the same Act talks about the custody of the child, that is to be provided to the victim with the periodic visit of the respondent if he wishes to have the same. Now, certain things needs to be kept in mind, that domestic violence cases cannot only be registered by the wife. It can be registered by any female who is living in a relationship, in a domestic relationship with a male member who has inflicted violence on her. Now, there are certain provisions which are very much extensively explained under this Act in order to ensure the safety and security of the victim of domestic violence. This is something that aims at protection rather than punishing the wrongdoer. Its primary objective is to protect the victim or the aggrieved person. That's all from my side on this Act. Thank you very much.